SJC-12951, Commonwealth v. Donte H. Henley, and SJC-12952, Commonwealth v. Josiah Zachery.
Ms. Essington, please.
Thank you. Good morning. May it please the court. Catherine Essington on behalf of the defendant, Donte Henley. It's my intention to use approximately half the time, so I would reserve the remaining time for my co-counsel on Mr. Zachery's case. I'd like to start with the first issue that I raised in my brief, the judge's admission of the 2014 shooting, in which Mr. Henley was observed by video fleeing the sound of shots fired on the street. This
issue is a bit different than our usual Barbosa case, where the Commonwealth certainly satisfied the same gun, the murder weapon requirement, correct?
Correct. There was ballistic evidence that linked the gun to Mr. Lamore's killing.
But your argument is a bit different in that he is on video fleeing from the scene and we don't know his connection to that firearm. But isn't it probative that the murder weapon is seen where he's in the vicinity of the murder weapon?
It would be probative if Mr. Henley was directly tied to the murder weapon in the earlier incidents, but all we have is that he was seen running away from the sound of shots fired. We don't have any evidence that he was in possession or even had knowledge of the gun in that earlier incident. And I think that's what distinguishes this from other cases where there is a direct link to the defendant and the murder weapon. In addition, no contemporaneous limiting instruction was given with respect to this incident, which is certainly a factor for this court to consider in determining whether he was unduly prejudiced.
And forgive me, Ms. Essington, I forget, was there a request for one contemporaneously?
There was, I believe, the counsel, first of all, offered to stipulate that the murder weapon in the killing of Mr. Lamore was requested by Mr. Henley, but he also moved for a mistrial. But there was, if the court looks at the record, the prosecutor even states that all parties agree that a limiting instruction should be given at the right moment, and then the court seems to simply forget that it said that it would do that and tells the jury, the judge tells the jury it'll give them a limiting instruction, but then never does until the final charge. Counsel's efforts to resolve this matter by stipulation show that he was extremely worried about the jury making an inference that Mr. Henley was involved in this 2014 shooting as a joint venturer, since there was also mention of another individual who was seen running from the scene. That again, this evidence was extremely prejudicial and fit into the Commonwealth's attempt to portray Mr. Henley as a very violent and dangerous person throughout the trial. And if there are no other questions about that issue, I'd like to move to some of the other issues in the case.
Can you address the other joinder issue, which I thought was more complicated? So your client's defense is identification, right?
No, that was Mr. Zachery.
Excuse me, that's Mr. what?
Mr. Zachery's defense was identification.
Okay, Mr. Zachery's, and your client's defense is self-defense, right?
Yes.
And I'm just trying to understand how Mr. Zachery, how you can do an identification defense when at the same time the other defendant is saying, I basically asked him to bring the gun.
I think that's a valid point, and I assume co-counsel will probably address that, but I think the defenses were mutually antagonistic, and that Mr. Henley's defense was essentially partly self-defense, but also partly that Mr. Zachery had misinterpreted his text messages and that he didn't really intend to have Mr. Zachery shoot Mr. Lamore, but simply to bring him his weapon to defend himself.
Is it a factual impossibility for mutual exclusive, or is it just prejudicial? Because the bar is very high on inconsistent defenses. That'd be mutually exclusive, correct?
Yes, that's the bar, and I think they were. I think it was certainly pretty much impossible for the jury to believe at the same time that Mr. Zachery wasn't the person who shot Mr. Lamore, but yet also believe that he had misinterpreted Mr. Henley's text. So I do think that bar is met. Just to turn very briefly to the Commonwealth's gang expert, I pointed out in my brief numerous problems with this testimony, but specifically want to highlight the gang expert's testimony claiming to interpret the text between Mr. Henley and Mr. Lamore, and suggests this was extremely problematic, where Mr. Henley's intent was really the sole issue with respect to his case. The expert really had no qualifications to be interpreting gang slang or text slang. He couldn't cite to a specific instance where he actually heard these phrases before. And it really went to the ultimate issue for the jury, which was what did Mr. Henley mean when he was making these statements?
You understand, though, that testimony that goes to the ultimate issue is not excluded because it goes to the ultimate issue.
Well, I do understand that some cases have said that, but I think there are also cases that said that an expert or any witness cannot testify directly as to a defendant's intent, that's really an issue for the jury. And that's effectively what he did in this case.
Well, he interpreted text messages. I mean, the prohibition is that the nature of the testimony impinges on the province of the jury, not that it goes to the ultimate issue. And here, the texts are being interpreted, and from there, you get another step to the state of mind. But we have a litany of cases, perhaps most recently discussed in Commonwealth versus Garden, that there's no reason to exclude evidence simply because it goes to the ultimate issue.
Agreed, but I think, again, that this really invaded the fact-finding function of the jury. It wasn't qualified, the testimony wasn't qualified in any way. He simply testified that, the phrase, punch him up means to shoot him. So I think he's really was testifying as to the intent.
Was he, counsel, excuse me, was the witness recognized as an expert in gang activity?
He was recognized as an expert in gang activity, yes, but not.
And also, was there any objection to that?
To his qualification generally? No.
Right.
No, there was not. I think there were specific objections to the testimony I just cited and to other testimony, but not to his.
What was the foundation laid that he understood what punch up means in these other, because the terms sort of don't jump out at you that punch up means shoot somebody. So how was it presented? How did they provide? Because it doesn't seem to me that if this were sort of standard terms of the trade, you couldn't really argue that he's weighing in on the ultimate issue. He's just providing, translation essentially. So it's got to be a foundation issue, not a ultimate, issue. Opining on an ultimate issue, isn't it?
Well, my argument includes that a proper foundation was not laid and he was not qualified to give this opinion. I think he basically testified that he'd listened to a lot of tapes of jail calls and claimed generally that he'd heard this phrase before, although he was unable to cite any particular instance when he'd heard these phrases before.
But that goes to the weight, though, because here I'm reminded of the drug cases, right, where you'll have a wiretap or something, and then they're speaking about, you know, deliver a box of shoes, and the cop will say the shoes actually means kilos, and we get into that issue. But here there was some testimony that this was a term he was familiar with, correct?
That's what he testified to, but I don't think that testimony was supported by anything in the record. Again, he was unable to cite any instance. He hadn't had any training in slang terms that he could testify to. So again, and also I just like to move to another aspect of his testimony, that his testimony about gang violence in general was very prejudicial, unduly prejudicial to Mr. Henley and Mr. Zachery.
Well, but counsel, here I'm a little confused, because didn't both defendants in their opening start with gang? You know, it was included in your openings, in the defendant's opening. So to go into this area doesn't seem uninvited by the defense.
Well, certainly Mr. Henley acknowledged in his opening statement his gang affiliation, but I think that's a really far different thing than talking about gang violence and specific instances of gang violence.
Isn't it essential to his self-defense claim that these two gangs are out to get each other, and he needs to have a gun to protect himself, isn't it?
I don't believe so, no, Your Honor. I think he established that they were affiliated with rival gangs, but I don't think that specific instances of violence were necessary to convince the jury that he had a reasonable fear for his safety. And some of what the expert testified to in this case involved gangs that were not even at issue in this case, that were not the ones that Mr. Henley or Mr. Zachery or Mr. Lamore were affiliated with. He just
doesn't the factor that Justice Kafka raised put this apart from like the Wadsworth case, where I think we've cautioned in this area where, and I think you're right, Ms. Essington, that in general, it's bad for them to talk about gangs and say, oh, by the way, gang members shoot and kill each other. But here, as Justice Kafka says, the defense is, I need a gun to protect me from this other guy, but it was only for protection. Is this mistake of fact, this mistake accident argument that he raises. But you know, if there wasn't a history of violence, why does he need a gun to protect himself?
Well, again, I think, you know, there was some maybe a small amount of testimony about this specific rivalry might have been okay, but the expert's testimony went way beyond that, and he talked about shootings and stabbings and ceasefire meetings and an ongoing feud between two other gangs in the Boston area. I think Mr. Henley established his reasonable fear through, again, the affiliation evidence, which is different from violence evidence. And he also elicited some evidence that another individual at Roca, Richie Williams, had brought a gun to Roca. That created some fear on Mr. Henley's part, as Williams was in the same rival gang as Lamore. So I think his claim was established without this evidence. So I guess I would respectfully disagree about the need for it.
Let me see if there's further questions. Well, thank you, Ms. Essington. And Ms. O'Brien now.
Thank you, Your Honor. Jennifer O'Brien for the defendant, Josiah Zachery. I also have numerous issues. I'll start, I'm not going to obviously get to all of them, so I'll start with the Charlie card issue, which I think is of interest to this court. I want to start by saying that the Charlie card did make a difference in this case. It was strong evidence of the defendant's guilt, and it was used by the Commonwealth for that purpose. It was used, the information from the Charlie card, video surveillance, and from the taps were used to get a warrant for the defendant's cell phone. It proved that he hadn't had a shovel with him and he wasn't walking around shoveling people's driveways, as he said. It proved that he owned the North Face jacket that was found underneath the stairs after the shooting. And it was used to link the defendant with each and every text and telephone call. Not each and every one, but a lot of them. And it was used in the prosecutor's closing argument where they said, here's the defendant is texting saying, I'm boarding the 29 bus, and here he is boarding the 29 bus. Yes.
Yeah, look, I don't think, I think I agree with you that it was powerful evidence.
Okay.
So I don't know if you need to spend a lot of time on that.
That's fine. I just wanted to cover that. So
No,
I guess the question is.
May I have a question? I have a preliminary question. Was there an objection made to this evidence coming in?
Yes, and there was I believe at the time, you mean when it came in at trial?
Yeah.
I believe there was, Your Honor. I know it was a motion. There was a motion to suppress, obviously, on it.
Yes.
But I believe there was an objection at the time.
So, Ms. O'Brien, I'm sorry, did you have another question, Justice?
No, that's it. Thank you.
Ms. O'Brien, let me ask you a few questions.
Yeah.
So, if the government had got the information from the Charlie card and only asked the police officer, only asked the MBTA for that one day, is there a problem?
I think there is a problem because there is case law that says there's a person has a reasonable expectation of privacy to their location. And
all right, so in Augustine, we gave the CSLI for 14 days, which is a lot more intrusive than a Charlie card for one day. So how do you distinguish Augustine if it were one day?
If this was only one day?
Yeah.
Well, I think it should be the 6-hour rule. I believe it's absent an exigent a situation, an emergency situation, which here there wasn't because the defendant was already in custody when they made this phone call. I think that this court should apply the same CSLI 6-hour rule as Augustine, and in this case, it wasn't. So I guess the answer to the question, if they did do it just for that day, then under that case, I guess I would agree that would be appropriate if there was an emergency situation, which I don't think there was because the defendant was already in custody.
All right, then let me ask you a different question. On this expectation of privacy, and forget about the subjective, right? It really focuses on the objective. When you go to Logan Airport, do you have an expectation of privacy if they were to pull your records and see every time I check in to travel all over the Midwest last year? Is there an expectation of privacy in Logan Airport?
Well, I think people are under the impression that there are cameras. Are you talking about? I guess the question is, how much information are they getting from you? You mean? So they
go to American Airlines and say, give me all the times that this person is checked in, and then they track it and say, geez, this person travels to Chicago a lot. Is there an expectation of? And then they pull a video surveillance from all over Logan and see me with my little carry-on. Any issues?
I think there would be. I mean, obviously, in today's world, people expect that a little bit more, I guess. And, if you, because of what's gone on with 9/11, you expect that there's more security when you travel. But day-to-day.
What's the difference between Logan Airport and South Station?
Well, I don't think there's much of a difference. Here, South Station, people are using that day to day. I guess if you have to travel for work every day, that's a different situation. But here, where there's people that don't have any transportation and this is their only means of travel, and they have to use the MBTA, I don't think there's an expectation that the government is tracking your every move.
Do you have an expectation of privacy in your transponder when you go down the Mass Pike?
No, I don't believe you do. And I believe that this is different than that because you know, you apply for that and you're putting in your window and you know that there's a camera. I guess if
Why isn't that the same for the Charlie card? You buy one, you see cameras everywhere, you know it's registering, it's feeding back information whenever you use it.
well, I guess looking at the McCarthy case, I mean, that's kind of the same as a transponder as far as just taking pictures of your license plate. Here, it's not, if you're driving on a highway and they're using a transponder, they're not using that with the video surveillance as they did here. And here, it's an aggregate amount. They use the two together. They use the Charlie card taps, then the video surveillance, which didn't just show where the defendant went, it showed what the defendant was wearing.
But if one's not a search, you know, it doesn't matter, right? So yeah, I mean, your issue is whether, and it's a very hard issue. And you've argued it well, but if the Charlie card seizure, there's no expectation of privacy, there's no search, then they can do whatever they want with the video, right? They get that if there's no Wong Sun fruit of the poisonous tree, if there's no initial constitutional violation, right? So it really flows on whether or not the Charlie card information had an objective, reasonable expectation of privacy, right?
I think so, but I think the court can also look at what it's used with. I mean, you can pluck somebody's identification, location out of the air, so to speak, and then use that with video surveillance. And under the mosaic theory, you're gaining more knowledge about the person as opposed to just where they went, you know, who they're with, how they're dressed. And in this instance, they showed the defendant walking back and forth and that he was using his cell phone. And obviously that was an important part of this case. So it isn't just location information and a snapshot in time. I think you have to see how it's used as well. I think the court should consider that.
Well, I'm not sure that's accurate for the mosaic theory. I mean, what we have here is a location being determined one place to another place. And that's what the Charlie card gives you. If, I think Justice Gaziano's point, well, if that's all it's giving you, how is that creating a mosaic of your life? This time of day you go to a religious location. This time of day you go meet a friend in the park. Here it's one station location to another, and that's the universe of information. And I think the point is, if that doesn't create a mosaic, the fact that there's a surveillance camera that gives additional information doesn't constitute another search.
Yeah, I understand what the court is saying. I mean, here, it's not just one terminal. There are 127 stations, 991 buses, according to the amicus brief that was submitted. There are a lot of points. So
was that before the motion, Judge? I'm sorry to interrupt you, Ms. O'Brien, but that's an important point, and that was the issue of McCarthy. It's in the amicus brief, but was that before the motion, Judge?
The details of how many stations and right. Whatnot. It was, I don't know if they gave the exact number. There was somebody from the MBTA, obviously, who testified the way it works, and public transportation.
Your position is the third-party doctrine's essentially a dead letter in this area, correct?
Yes, absolutely, absolutely.
Tell me exactly what information was gotten about your client. And I mean, I didn't think that there was exit information. I thought there was only entrance to where he was, that he poked his card in the machine. That would tell you where he was. It didn't tell you anything more about where he went, did it? You mean absent the video? Yeah, absent the video. The use of the card itself only got you to where he went into the station, right? It doesn't tell you where he left.
No, it did not. Not the card itself. And I think it's important, though, what was requested here was an open-ended request. It was, I think they got up to a year. And just because they only used a couple of those dates, I think the court under Estabrook has to look at what was requested. And here the MBTA said that there was, 14 months is how long they hold it for. So I think there's an expectation of privacy. If you, under the mosaic theory, you're requesting 14 months, that's a lot of information on individuals travel.
Which went to my first question, right? If it was the day versus the 14 months.
Yeah.
But that's not your concern under Estabrook, because that's what they seized, was the 14 months.
Exactly, yes.
Even if they used the one day.
Yes, they didn't request one day, and I think that's an important distinction here. If they had requested one day under Augustine and the 6-hour analysis, then I would tend to probably agree that the same rule should apply. And I would note that I think there's the motion judge kind of distinguished Augustine. I think there was kind of a misreading. My understanding of CSLI is that there's telephone CSLI and then registration, and telephone requires a person, it's an episodic use. It requires someone to take an affirmative action to get for the government to get the location, and the other one is just general. And I think that Judge Ames referenced that as a continuous, that this wasn't continuous surveillance. And here, I would argue, like Augustine, it is episodic. It does obviously require the defendant to take an affirmative action in using the card.
I think to maybe amplify what Justice Link was asking you, in McCarthy, we were looking, for lack of a better word, at data points, right? So we had 4 cameras on a bridge coming and going from the Cape. And then where they go after that, who knows?
Yes.
So we have the entire MBTA system they accessed. So we have your client taking I think it was a subway, a bus, then a train, correct?
Yes.
To get to JP. So the question is, how much could they track based upon what they get from the Charlie card information, independent of the video surveillance, which flows from it? But
yes, yes.
So where does that fit within McCarthy, I guess, is my bottom line.
Well, and I think it brings me back to the video surveillance. And I know that's different, but the video surveillance, my understanding, when you look at the two together, what the government can find out about someone's life or travel, way they travel, is just the McCarthy to taking a photo of the license plate. And here, they're not only getting the location where the person is, but when you can't ignore the fact that it's used with video surveillance. I mean, that was the testimony in the motion to suppress, that the police said they know that they can match it up with video surveillance and find out who that person was who used the card. So
have we done that though? I mean, so if the police, if you bring a motion to suppress on a firearm case, and the judge disagrees with you and says, no, there was consent to seize the firearm, so it was lawfully seized. Then the police take the firearm and they test it and they link your client to some heinous, triple shooting. Once they have the lawfully obtained firearm, they can analyze it and do whatever investigatory techniques they want for lawfully seized evidence, right?
I understand that, but here they're using the video surveillance to identify the user. I think that's
powerful. It's incredible. I mean, that's why I don't think you had to waste any time telling us it was impactful, because it surely was.
Yes, it's not something
very powerful evidence.
Yeah, I don't think it's something that's acquired after the fact, where you get a gun in with your example, and then after test it and find that it's linked. This was used with the video surveillance at the same time, simultaneously, to see who the person was using that card. I mean, they had to be used hand in hand. Without that, then obviously if they found the Charlie card on the individual, it would be speculative whether
but
it was.
The card doesn't give you it's not like TV. The card doesn't give you the video, right? So they have to say he was in South Station at 8 a.m. Then they have to go to the South Station at 8 a.m. say pull the videos. Am I wrong about that?
No. To confirm that, unless the card is registered to a particular individual, where they're putting more money on it, then they can certainly. And then it would still though be. I think a defendant could argue it wasn't me without video surveillance, that somebody else.
If I pay cash for a Charlie card, there's no no problem. They can't track it.
They can't track it.
They had
if they
his
found it in your pocket.
Right, it was in his
like
pocket,
this.
and he of course, it was registered to him through some school program, right?
Yes, yes. So it was in his pocket. So if it's in your pocket, then they have an argument that this was you. And
so, the video surveillance proves too much in a sense, though, doesn't it? Because an individual is going to understand, even if it's not Logan Airport, if it's South Station, if it's the Park Street T-stop, that the nature of life in 2020 is that there's going to be video capturing where you are. And one of the issues that we look at is, could this information that is exposed be obtained with normal law enforcement tools? So does the presence of the video cameras prove too much?
No, I think people do expect, obviously, to be captured on video, but you have to look at the duration of the surveillance, whether it's continuous, whether police are able to pull in someone's location. Real-time data, obviously, is a police officer sitting and watching the defendant come through the turnstile. Here, it would have been impossible for police to conduct this surveillance because, first of all, they wouldn't have known when he was coming, but to plant a police officer at every single MBTA station, it's not possible. So certainly this type of surveillance wouldn't be possible without this modern technology.
Yes, but don't you have the problem, like, is the surveillance separable from the Charlie card? I guess is my question. Is the surveillance separable from the use of the Charlie card for its location data? As I understand it, maybe I'm wrong about the way I understand it, when you swipe your Charlie card in, and it gives the MBTA information about where it is that you did that. And that's it, right? That's where you were at what time you were. That's all it tells you, right?
Yes, the Charlie card information.
Yeah, and that's all that they got from the Charlie card per se. You're saying it's because of that it's the link up with the surveillance system that is the problem, that the MBTA maintains also a surveillance system. I guess what I'd like to know is, can you just get into the surveillance system without the use of the Charlie card? Suppose somebody didn't have a Charlie card. Suppose somebody was just paying their freight, and you know that they were likely to be on the Charlie. They were likely to be on the MBTA. So you want to check the surveillance system. I understand that there are, like, with the bomber in the marathon bombing case, and in England they have all these cameras every place. Don't they have these experts who can just sort of swipe in and sort of see things from the surveillance alone?
Certainly, and there's nothing wrong with looking through surveillance, but in here, that's not what happened. I mean, there was a number given, a serial number, and that led them to know exactly where to look for surveillance. So whether
if they know where Mr. Zachery lives, right?
Yes.
And they didn't have this information, they said, all right, the way to get to JP from where Mr. Zachery lives is to go through whatever train or whatever bus. Let me pull the surveillance from those trains and buses for 6 hours in between the time of the homicide, which I think is close to Holly, what they did in Holly. But anyway, that's not a problem, right?
No. But
and how is this, so they have this information. How is it? I mean, it may be the breadth of it. The 14 months is the issue, but
I think it is. In it's disputable whether it was raised below, but before they even read off the serial numbers and use that for investigative purposes, my understanding is they're supposed to get a warrant for that, which they didn't. They just, they just took the serial numbers and made a phone call. It was as simple as that.
But if there's no it's circular. If there's no search, they don't need a warrant. But that, we have to decide that, right?
Well, I think it's similar to, I think it was the Seng case, where the defendant had a bank card on his possession, and they used those.
But in that case, that had his name on that was registered, and it was a different kind of search, wasn't it? It was an inventory or something, and they looked at the numbers and.
But here they looked at the numbers the same way. They read the serial numbers, and I would argue it is the same. They should have, because there was a specific number. It's not just a random card.
But so we go back to the argument of whether it's a search or not, because in the I think I forget the name of the case myself, but it was also that was a clear search because of the circumstances surrounding it.
Yes, I think this was a search to use the card for investigative purposes, you know, initially without getting a warrant, to make the phone call to the MBTA, and then I'm arguing that it was a search with obviously what they got back after they called the MBTA, which was at least a year's worth of travel.
So your argument would really be that they needed probable cause and a warrant to investigate that Charlie card.
Yes, absolutely. They needed a warrant. That's the argument.
And Ms. O'Brien, we're going to look at all the issues you raised, including a real tough issue about the stop of your client in his detention and the like. Let me just ask if the justices have any other questions of Ms. O'Brien. But we will look at all the issues you raised as well. I know Ms. Essington raised a whole bunch of issues.
Not enough to get through, yeah.
Yeah, no, we only have so much time, but I appreciate it. Thank you.
Thank you very much. Appreciate it.
Mrs. Shorey, how do you distinguish this? Well, actually, maybe we should talk about Mr. Henley's case first to go in order. Here, he has this defense, and he's not seen in possession of the firearm. How is this, in every other case we have, Barboza and all those other cases, there was a link to the person using the gun. Here we have video of him running away. How do you get that?
Well, I think really what that comes down to is that, you know, can the jury draw an inference that he had access to the firearm given the connection on these two separate dates and his request in the text messages for his firearm to be brought to him? I think his argument is that, well, the jury, there may not have been enough there for the jury to say he had access to this firearm, or that the link at least to the firearm wasn't as strong as in other cases. But to the extent that's true, to the extent the jury found or doubted whether he had access to that firearm on the first date, you know, he certainly wasn't prejudiced by the information. And I do think that goes to the weight of—
I mean, it diminishes the probative value, and we caution that it's highly prejudicial to link a defendant to firearms, right?
Well, it is prejudicial to link him to the firearm, but in this case, if he's in fact linked to it in the jury's mind, then its probative value, I think, is very evident. So the issue, this isn't an issue where there's a firearm found, for instance, in the apartment, and it might have belonged to someone else, where there might have been some additional prejudice from that. The defendant's argument at trial, at least, was, look, the defendant might have just been running away from this gunfire, in which case I don't think the jury could have drawn any negative inference from that. But, you know, the jury does not have to, you know, the evidence doesn't have to, you know, be beyond a reasonable doubt to get to the jury for them to consider it as probative, especially where the, you know, his link to, you know, yes, it is a circumstantial case to some extent against him.
Let me ask you, Mr. Shorey, about that point, please. So did the judge, before allowing in the evidence of the prior bad act, make a determination that a reasonable jury could find that he had knowledge of the gun from the circumstances? In other words, what's at the core of Justice Gaziano's question is a conditional relevance question,
right?
And there's no relevance to the later event unless the earlier event is satisfied by the standard of conditional relevance.
I don't remember the express language the judge used in finding that evidence was admissible at the pretrial hearing. but I mean, I think implicit in that finding and the admissibility of evidence, that's always the finding. And I do think it can be, the evidence can be linked up by later events, the text messages and the finding of the same gun, and and the number of cases where the defendant, for instance, was seen driving a car that was similar to the one that was at the crime scene, right? It's linked up by that later evidence, and it's not beyond, it's very certainly couldn't, find beyond a reasonable doubt.
No, the standard for conditional relevance under 104B is whether a reasonable jury could make the finding by a preponderance of the evidence.
That's right. And I guess what I'm saying is I'd suggest here that you can consider the evidence that comes in later about the text message. I mean, with the video by itself, could you find, that may be a close call on whether the jury could find that. But with the later text messages saying, bring me my gun, and then the finding of that the murder weapon was at that prior incident, I think those three things together is more than enough for the jury to find probative value in that, or at least access to that firearm that this was.
Right, Mr. Shore, was that enough? Are you finished, Mr. Justice Lowy?
Yes, thank you.
On the gang evidence kind of got away. I mean, it seems to me that they put a lot in that they didn't need or that was prejudicial. I mean, you've read Wadsworth, where we talked about gang experts kind of running amok, talking about violence and shooting and the like. And here we have him interpreting text messages. Could you address the text message interpretation, and two, the testimony by the gang expert about this mayhem that we've said in Wadsworth is not permissible?
If I can address that second issue
sure,
first.
Whatever order.
Sure. I think we can't overstate enough the importance of that evidence to Mr. Henley's case, in addition to the Commonwealth's case. In his opening statement, he didn't just address that there would be gang evidence. On page 28, volume 4, page 28, he specifically says there will be gang evidence about violence. And so it was part of his case from the beginning. He had moved in limine to admit that gang evidence would go to his state of mind. So I think it was important to both cases and probative for both cases. Now, I do get that he objected to some of the evidence when it actually went to be admitted at trial, but I think that still factors into the probative value outweighing undue prejudice. In comparison to Wadsworth, the issue in Wadsworth was the same as it was here. What was the motive for this crime? The motive allegedly was this conflict between these two gangs. But the evidence went well beyond that, just that there was violence and that there could be feuds between gangs. That the evidence was specifically that the crimes they engaged in were distributing drugs at playgrounds and schools and engaged in prostitution and other things that really had nothing to do with that rivalry. But the violent acts between gangs is entirely relevant to that the ongoing feud, and that's what was really admitted here. So I do think there's a distinction between the type of evidence that was admitted.
What about the text messages?
The text messages, I think, to the extent it's a foundation issue, I think the Detective Ford testified to listening to thousands of hours of jail calls. He testified to conducting more than 100 gang member interviews, that he walked the streets trying to gain information from people in the areas of gangs to discuss.
I get he knows a lot about gangs. What was the basis for concluding that punch up and the other statement meant shooting them? Does he say he's heard those? Does he connect those words to other shootings and stuff? I mean, how does he do that?
Well, he absolutely says he knows, he's heard those words, those phrases to mean those things. The defense in cross-examination asks, can you give me like a specific instance where you heard that? And he can't think of a specific instance. But I think this is very similar to, I mean, really we're talking about an interpretation of language that not everyone is familiar with, which could happen with any number of languages. And people learn languages over many years and with common usage and within those languages. And so I think that's really what we're dealing with here. And again, the issue is whether this is enough for him to testify to it, and then the defendant is free to rebut that. But I think there's plenty here for the jury to find that that's what, he has an understanding of what these terms mean.
Mr. Shorey, before you, sorry, go ahead, Mr. Scasio.
I was going to say, but I wanted to address the severance issue. I don't know if you're going there as well.
That's where I was going.
Yeah, I think you had that question before. You want to, why don't you ask your question? Yeah, I want to know, why was there a joint trial? Justice Kafker?
I guess, to me, I'm just trying to, and again, I understand it's a very high standard for the defendant to meet here, but so Mr. Henley has got a self-defense claim that he needs somebody to come bring him a gun to protect him from the other rival gang member. Mr. Zachery's defense is identification. Are these mutually exclusive in this context? I mean, one guy's saying I called him up to bring a gun. The other guy's dead, isn't he? And I mean, I'm just trying to understand how this works.
Right.
And why they're not mutually exclusive.
Sure. So I do think there's some there's some tension there. I think the way it plays out at trial, and as it's represented by the prosecution beforehand, the only evidence implicating each of the defendants on their, well, in entirety, but on their particular theories of identity and miscommunication was the Commonwealth's evidence that would have been admitted in both trials. Mr. Henley, I think if he had acknowledged a relationship with Zachery, or if any evidence about his gang involvement with Zachery had come from Mr. Henley, maybe a different thing here, but that wasn't the case. And he didn't even, he was very clear in his closing argument and opening statement that he wasn't saying Mr. Zachery was the shooter. He never referred to Mr. Zachery.
We have all the cell phone from Zachery to, Henley to Zachery, or Zachery to Henley. That issue is a goner, right? I mean, we know they're communicating between each other, and when Mr. Henley is basically saying, I need the guy to bring a gun, I guess he's basically saying, I didn't tell him to shoot him, but I told him to come bring the gun.
Well, he says
Mr. Zachery's up, the proverbial creek without a paddle at this point.
Well, I disagree, Your Honor, to the extent that evidence all comes in even if Mr. Zachery is tried alone. I don't think there's any piece of evidence that I can recall certainly that comes in that the jury's having to disregard, or that in any way one party implicates the other that doesn't come in at that trial individually.
Does that lead to the conclusion that if we suppress the Charlie card information, Mr. Henley gets a new trial?
No, because he still, he never had a standing issue here. The judge let it in as, I think if let's say the motion had been allowed, or you find it should have been allowed, and the parties were tried separately, I think that evidence would come in against Mr. Henley regardless. The judge allowed him to join this motion to suppress.
Wait a second. So we have so if we're in a separate trial, right? Say there's a drug case, and we suppress the kilo of cocaine against co-defendant 1. You tell me that when co-defendant 2 goes to trial, the government can put that kilo of cocaine in?
Well, if it depends what the charge is exactly.
It's a bad example because it's a possessory crime.
Right.
But the evidence, the Charlie card evidence, was damning against both certainly Mr. Zachery, without question, and certainly Mr. Henley, because it tied the whole thing together. So
it was damning, yeah.
Profit from an illegal who he seized evidence against Mr. Henley?
Well, because it wasn't. I think that the standing issue in suppression cases, I do think, controls here. He didn't have standing just I mean, this case involved another person being stopped by the police as well, but neither defendant could challenge that and any evidence that came from it because they weren't seized. I think the court has reiterated that principle, very recently in the Mora case, in addressing some of the co-defendants who were away from their home, who were only monitored away from their homes. So I think I absolutely think that Henley, unless he establishes an expectation of privacy, can't join in the suppression. I would note that Mr. Henley also, what he sought to join was the suppression of the phone. At least that's the argument beforehand. That's what he's arguing, that he had an expectation of privacy in the telephone communications, not the Charlie card information. So
this issue again raised something that we've been struggling with in Commonwealth versus Mundy, and whether or not the standing issue and the expectation of privacy issue actually end up at some point merging.
Yes, I mean, I don't know that you have to get there in this case. I just don't think there's, I really don't think Mr. Henley comes close on anything here, establishing there's a search or establishing standing. But I think, it certainly, I don't know that it's relevant here because I think Mr. Zachery, the issue there is really just the expectation of privacy, not the initial standing. And I just don't think Mr. Henley comes close on either.
Let's get to the Charlie card unless people have other questions about Mr. Henley's case. All right. How is this not controlled by McCarthy, the 14-month grab, as opposed to 1 day?
So I think the issue of what time frame we're talking about.
Don't say third-party doctrine.
I'm not going. I understand that's not your question.
Right. So go ahead.
But aside from third-party doctrine, the issue of whether we're counting the time frame that's requested, or the time frame that's obtained, or the time frame that is this Commonwealth seeks to introduce at trial, right? I think that what the Commonwealth seeks to introduce at trial really only applies in where the Commonwealth has actually obtained a warrant and a judge has signed off on that, but improperly for too much information. So I think that's out. But in terms of what was requested and what was obtained, the search, to the extent there was a search, it is for what was obtained, not what was requested. And I think that McCarthy absolutely supports that proposition.
So all right. So as far as they asked for, because they retained for 14 months, and maybe I'm wrong on the record. What did the MBTA police physically give to the Boston police?
So they gave them the data for the morning of the murder and for one prior date a couple weeks before. And
where's the 14-month come in? So they never gave them the 14 months?
Correct. The police officer, the Boston police officer, requested really a very open-ended question for the information you have on this. The MBTA, in fact, keeps 14 months of records, but the record only supports that they pulled two dates. So that's the information that was obtained. And so I think the case does fit very neatly into McCarthy, where we're talking about very limited data points over a very, very limited period of time. And I think Mora addresses this too, when it talks about the significance of episodic data as opposed to continuous data that you might see in CSLI or GPS.
So they to use an analogy, they seek a search warrant for the entire warehouse. They go in and they search one of the outbuildings, which they had probable cause for. Right, so their actual search was more limited than the search warrant, than the permission they got.
Right. I think that's a fair analogy. If they don't, what we're concerned about is the reasonableness of a search that actually takes place. And
do you think the 14-month, if they got the 14-month, would that be a problem? Would that be McCarthy?
Well, so there, I still think that we have to look at the specific data that's provided. It really does. You know, I think that there's a good case to be made that the nature of the information provided is such that an individual really never has an expectation of privacy in that information, since all they're getting is the point at which they enter a public transportation terminal, where you can imagine someone using this every day for a commute to work and even to go to other locations. But at the end of the day, what you get is the approximate location from which they leave on their daily commute. And I'm not sure someone has an expectation of privacy in that. It's hard to imagine a scenario in which one can gather their personal associations, religious, political, or otherwise, that's been referenced in the recent cases. But again, I think even if there's a scenario in which exclusively getting, you know, transfer points and entrance points at public transportation can reveal those types of associations, what you should look at is what is actually gathered in particular cases.
How about as to destinations? Is there information that is compiled by the MBTA as to persons' destinations? If you take this in consideration with the surveillance cameras.
So I think that in this case, that's somewhat what happened, that they tracked the surveillance cameras from Forest Hills. But yeah, I think it presents a pretty difficult question when the mosaic theory presents a difficult question as to what exactly is included in the mosaic. Yeah. Because if we're talking about subsequent investigation based on this initial information, then I think the information that's included in the mosaic just becomes exponentially large. And you know, really, I think here the information that should be included is what they pull from the Charlie card information, not the surveillance video, where we have clear statements about certain people not having an expectation of privacy from surveillance video in public locations.
Well, it's the linkage. Isn't the problem the linkage between the surveillance information and the Charlie card? If you couldn't get at the surveillance information absent the Charlie card information. Isn't that the contention here?
Well, I don't know if it's true that you couldn't get at it without it. I mean, I think the police reasonably conferred once they found the Charlie card that Mr. Zachery came from Forest Hills, for instance, and pull an hour or two of surveillance video and obtain the same information. So I don't know that it couldn't be done, but I also think even if the initial data leads to that surveillance, you know, do we categorize it as, or should it be categorized as subsequent investigation or as part of the information collected in creating the mosaic?
Ms. O'Brien's framing the issue in a different way. I certainly understand your point, but she's framing the issue as when you look at the mosaic theory and you have an issue of this many data points, that the nature of the intrusion is that you're going to find out a whole bunch of information about this person, not just that they went from point A to point B, but what they're wearing that day, who they're with that day. Do they look like they're feeling well, or they're having some issues, some health issues with their leg? Are they limping? There's a whole bunch of information that can be obtained when you have these multiple data points. And a way to demonstrate that is to say, look, you've got a surveillance camera as well. So they're not creating a dichotomy there. What they're saying is it's the whole thing together is the mosaic.
But and I understand that, and I suggest that when you put that data together, you're still not obtaining private information. When, you know, of course, with the Charlie card alone, it's anonymized. It's really very limited information. When you put it with the surveillance video, you might learn that this particular person was there at a particular time. You mentioned having a limp, being with certain people, but I don't think a person would expect to maintain privacy that they're walking with a limp, or they're with a particular person while they're standing in a public transportation terminal. They can be easily seen by other people. They can be easily seen by visible surveillance cameras.
Let me ask if there are any further questions of Mr. Shorey.
I have one, which is that suppose we think you're wrong about the Charlie card issue. What does that happen? I mean, do you lose?
Yeah, I'm not arguing harmless error as to the pulling of the data on the Charlie card, certainly for that morning. I think that you might have an issue, or I would suggest that if for whatever reason you were to find that the pulling of the Charlie card information was okay for that morning, but the prior single date was not, I think that excluding that date in and of itself, I think that would be harmless error. But I'm not suggesting that as to the Charlie card data in total.
But wouldn't the Charlie card data come out of the application for the warrant?
It would, yeah, and I mean, I don't. That's not my primary reason for not arguing harmless error. I think the evidence came in at trial and implicated Mr. Zachery pretty directly, and I think the warrant would be supported even without that information.
Well, that reminds me, actually, I had a question about the warrant. Doesn't the warrant rely a lot on assumptions about cell phones? I mean, later on, you have tons of probable cause, but it's not in the warrant about the use of the cell phones. As I read the warrant, and I might be wrong, it relies on a lot of the Commonwealth versus White assumptions about people carrying cell phones. There's a lot of generalities in that warrant. How do you get beyond Commonwealth versus White to save that warrant?
Well, respectfully, I think there was a lot. Most of the investigation was included in the warrant up to that point. So that the information about the stolen shovel and the footprints on the porch and things like that directly implicated Mr. Zachery were included.
Right.
And
you showed he was probably the murderer. But what's that have to do with the cell phone?
Well, and the link to the gang evidence was also included there. The police at that point knew and included in the warrant that the victim was a member of one gang, which had a rivalry with both Mr. Henley and Mr. Zachery. So there was that kind of direct link to that theory, and that they now know that Mr. Zachery came there that morning with that there's probable cause to believe that's part of this ambush. So they have a reason to believe that there's direct communication from Mr. Henley or someone else on scene, in part because this is a traveling work crew, so it seems unlikely that Mr. Zachery could have accomplished this by himself.
Was that in the warrant about the traveling road crew and they needed to locate the guy? I didn't see that.
Yes, it is.
I'm looking at it now. We'll take another look at that. I didn't remember reading that in the warrant.
Yeah, it's in the last couple of pages of that warrant, I believe. But
we'll take another look at it. Any further questions of Mr. Shorey? Right. Thank you, counsel.
Thank you.